Now let's talk about a very sensitive topic, that is children aging out and the Child Status Protection Act. And Rohit, let's start with you. What is CSPA? How does it work?
There's no way to say it at a simple level, but at the simplest level, the law is intended to protect children who are otherwise going to age out, meaning turn over 21 when when they're ready to get their green card. In its simplest form, for people to understand, the age of the child freezes when the petition is filed.
Mhm.
It remains frozen, not the biological age, the immigration age, or the make-believe age, whatever you want to call it, remains frozen as long as the petition is pending with the Immigration Service. So if my son was under 21 when the petition was filed and is now 22 when the petition is approved, if the petition was pending for 2 years, I get to take off the 2 years from my 22 and the child would still be under 21. If the petition is approved in 7 months, my child is going to age out because he's going to be over 21 when the petition was approved, even after deducting the time that it was pending at the Immigration Service. You now get into complicated issues of what is the age, or how is the age of the child going to be calculated at the consulate and for consular processing, and that may be beyond the scope of this entire conversation, but that complicates life. I've had wrong decisions made at the consulates, which we have got overturned in Washington, D.C., but it has still, unfortunately, hurt the individual because of the timing and the retrogression and stuff like that. But you got to be careful about that. They have now also passed internal guidance, which kind of offsets a good guidance that they had passed earlier and says you now have to use the final action dates, which, according to people who are familiar with the Visa Bulletin, that's the date when you potentially can be issued the green card because the visa numbers are available. You got to use that date for calculating whether the child is aged out or not. Earlier on, they had passed an internal guideline which said you could use the filing dates, not the final action dates.
Right.
And then there's, of course, the tension between what is being followed at the U.S. consulate by the State Department and what is being followed by the Immigration Service. So this is a very sensitive subject, which you're absolutely right about that. You must discuss that carefully with your attorney. And even there will be, according to me, there will be points in time where the attorney can give you a best judgment call or a best guess, but you're going to have to wait to see how it eventually plays out.
So, qualifying dependents for an EB-5 petition are spouse and unmarried children below the age of 21. That's why the age of 21 was mentioned. It is a very important age. And for immigrant visas, if your child is already over the age of 21, they do not qualify with parents. In that case, you will have to file their petition separately. But if they are under the age of 21, they will qualify with their parents, provided the date, the priority date is current. If it is not, then obviously Child Status Protection Act comes into play. And even when it's current, it comes into play because we want to lock their age in under 21. Now, this, as Rohit mentioned, it's different for consular processing and adjustment of status. And different attorneys have different views on it. So I want to specifically also talk about when, for adjustment of status, does the age remain frozen for longer, even if there is retrogression, versus consular processing where you've not filed adjustment of status? So, for example, if my child is 19 years old and India is retrogressed by 3 years, what is the difference between filing under consular processing versus adjustment of status? That's the question.
Yeah, I was going to say, I think, and this is where there's the differing perspectives. It's when it comes to the adjustment of status. I think the conservative view is that, okay, your age locks at I-526E filing, and then it unlocks at I-526E approval. If you're retrogressed, then the age starts to clock right away until a visa becomes available again, i.e. the 485 does not necessarily lock in the age. I don't recall the exact provisions in the policy manual, but it's a little bit contradictory where in one place it suggests that because you're filing the adjustment when a visa is available, that should lock in the age. But, I think it's also one of those things we're not going to know until an child actually ages out relying on that provision, and then B, it may have to be litigated. But I think the conservative measure is just to the age locks at 5 to 60 filing only.
Got it. Brandon,
I
what
don't
are
know what
your
you guys
views?
think.
Yeah, and so my opinion on the matter is that the Child Status Protection Act has a quote in there about seeking to acquire permanent residence. So in
Mm-hmm.
my opinion, there's no higher form of seeking to acquire permanent residence for someone in the United States than filing an adjustment of status, which you can only do if there's a visa,
Right.
well, at least under Chart A, if final action date, if the visa is available at that time. So, but yeah, I mean, this recent guidance that came out, yeah, throws a little bit of, so it's almost kind of like, you know, Oasis' first album. It's going to be a definitely maybe when the time comes. But, strategically, I think we're back to a situation where, pre-RIA, where we didn't have concurrent filing, the advice most of us gave was like, hey, if the child is 18 years of age or older, it's probably worth considering having that child be a principal applicant. I think, we might be back to those days as well. So if definitely, it's one of those things like you don't want to find out the hard way. So if child is 20, 19 or 20, even with concurrent filing, like, I don't know, like it may not be worth it. And that it might just be, depending on the family dynamics and who ultimately wants to benefit from EB-5 and how much funds there are to do it. That might be a situation where you do two EB-5s just because you don't want to find out, and and adversely in the future that, oh, the policy's changed again, and now and it's changed in the negative. Um,
Right.
these are all things that deserve consideration.
I was going to say we've consulted, in that exact situation. We've had clients come to us and we've sort of walked them through both interpretations of CESPA. And I do believe that there's room for litigation if they were to come out otherwise. And
Yeah.
so we do have some clients who are okay going down that road.
Yeah, I think this latest interpretation or guidance from the immigration has kind of definitely thrown a spanner in the conservative understanding that once you filed your AOS, and you could only file it when the visa numbers were available, you were fine. Your age was frozen. You didn't need to worry about it. Now they've kind of talked about it a little differently, and I'm also inclined to agree with Brandon and Neeral that you're probably going to see litigation on this issue, because I don't know who all and how many people it's going to impact. So this is a bit of a moving target.
Yeah, and tactical use of writ of mandamus
Mm-hmm.
in these situations, absolutely critical.
Yeah.
I mean, I also advise parents to be patient in terms of file the petition in your child's name. Your child's anyways going to be over 21. 5 years later, from the receipt of a conditional green card, they become citizens and they can sponsor you. It's asking a lot in terms of patience. It's like a 7-year wait. It's still shorter than the 40, 50-year EB2, EB3 wait, but it's asking a lot for a parent to just invest in the child's name. But here's the thing, that is the only way to keep the family together. If you have money to just file one petition, you're better off filing that petition for your child, and your child is anyways safe, no F1 visa required, no H1B required, they'll be here, and then they can sponsor you when they turn, I mean, they're already 21 and they become citizens. So, and that is free. So if parents are willing to do that versus take a risk and find out 2 or 3 years later that that child doesn't qualify with them, I think that's worse.
Yeah, but it also complicates life when you've got more than one child.
Right.
And the second
It
child or
does.
third child certainly qualifies. That's the reason why I think why Brandon also said we all agree that it's so important to understand the family dynamics and who
Absolutely.
really needs, not just wants, but who really needs that EB-5 as a priority.
Yeah, we've
Correct.
seen this change a lot with, the particularly markets in China and Vietnam, where pre-RIA there was this kind of feeling that the whole family had to participate in EB-5, even though the whole family didn't really want to or need to. And now when you have concurrent filing and then some, parents are are in the home country and the child studying in the U.S. You say, okay, well, it doesn't make sense anymore, which is something that, getting back to like the previous demand, lowers the kind of demand for visas overall. That in the past, like one petition for out of Vietnam was like 6 or 7 visas. Now it's like maybe 1 or 2 or 3, and so yeah, these all come into play. But yeah, unfortunately, it's something we have to start thinking about again.